What is the impact of Muslim Women Protection of Rights on Divorce Act 1986 on Section 125 of CrPC? Chapter 9. CrPC under the caption Order for Maintenance of Wives, Children and Parents is a self-contained legislation having only 4 sections, Section 125 to 128. This is a social legislation with the clear objective of protecting the basic financial needs of weaker sections like women, children, and aged parents. The provisions are drafted with a clear vision to do complete justice to the object to be achieved. Humanitarian considerations and ground realities are taken note of while framing the provisions. Its secular character is also worth mentioning. When a genuine claim for maintenance comes, no loopholes are left to the opposite side to resist it. The execution of maintenance order is very easy. Thousands of deserted wives, including divorced wives, throughout the nation could avoid starvation, at least to some extent, cutting across the barriers of religion by availing the speedy remedy under Section 125. Personal laws are not allowed to curtail this right. This provision of law worked smoothly years together throughout the nation, and it stood the test of time. While so, the Muslim Women Protection of Rights on Divorce Act 1986 was enacted. In fact, this new legislation overturned the basic principle upheld by the Supreme Court in Muhammad Ahmed Khan versus Shah Bano Begum and others that a divorced Muslim woman is entitled to claim maintenance from her former husband under Section 125. It carved out the Muslim divorced woman from the purview of Section 125 and conferred on her a right to claim a fair amount, giving importance to Muslim personal law principles. Section 5 of the Act further gives an option to the divorced wife and her former husband to choose the maintenance procedure under Section 125. This option is bilateral. Right-thinking men criticized that it was an unnecessary legislation. There was also criticism that it only helped to create confusion and sectarial feeling. The statement of objects and reasons appended to the Act and the provisions incorporated in the Act do not tally each other. This led the Supreme Court to pass the following comment in Daniel Latifi versus Union of India. If the language of the Act is as we have stated, the mere fact that the legislation took note of certain facts in enacting the law will not be of much materiality. While dealing with the purposive interpretation to be given to Section 125 to achieve the social justice envisaged, Supreme Court again evaluated its historical background as follows. We already have examples of exemplary efforts in this regard. Journey from Shah Bano case to Shabana Bano case, guaranteeing maintenance rights to Muslim women, is a classical example. The confusion created by the Muslim Women Protection of Rights on Divorce Act continued for about 15 years in one way or other. Finally, the landmark decision of Apex Court has come in Shabana Bano versus Imran Khan. In this judgment, Supreme Court in clear terms held that a divorced Muslim woman is entitled to claim maintenance under Section 125 from her divorced husband till her remarriage by approaching the family court. It can be further gathered from the observations and factual background of the reported decision that the concurrence or consent of the divorced husband is not necessary for claiming maintenance by the divorced wife by resorting to Section 125. Coming to the question, the Muslim Women Protection of Rights on Divorce Act has no impact from practical point of view on the right of Muslim divorced woman to claim maintenance under Section 125 from her former husband. For latest and important legal updates, please subscribe our channel.